My name is Alex Crate. I work for the Co-op in their estate planning division, and I've been involved in estate planning for now 18 years. Over the 18 years, I've seen a lot of things go very well. I've seen a lot of things go very badly. I've met a lot of families that have had difficult experiences, and I'm pleased to share with you tonight the things that people have done that have worked well, and the things that people have failed to do that have had an impact later on. I'm conscious this can be quite a serious subject, so I'm going to try to keep it as light-hearted as I can when we're talking about things like inheritance tax and care fees. Not always the most exciting of subjects, but we'll do what we can. So I'm going to start this evening with a thought which might surprise you. So after 18 years, I've come to a conclusion that there may be no point in making a will. What? You're probably thinking, why is he here then? Well, let's think about what a will is and what it does. A will is a legal document which gives away what you own when you die. So what if there's nothing left behind? What if there's nothing to leave? What could stop there being anything to pass on to your beneficiaries? What could erode your wealth? That's what we're here to talk about tonight. And then what steps you can take to plan ahead, protect what you worked hard for, and make sure your will does have wealth to pass on. So we're going to look at some of the issues that affect families, the impact they can have, and the type of things you could do to plan ahead and protect what you worked hard for. We're going to start with inheritance tax. Now, throughout the session, I'm going to stay on screen as much as I can, but we have got a couple of slides to help support some of the things we're going to talk about, and my colleague's going to bring those up when I ask her to do so. But for the majority, you get the pleasure of looking at me. If you get bored of looking at me, unpin me, and you can look at whoever else is on screen. Inheritance tax. Some would say, what a lovely problem to have. Did you know that a couple have up to £1 million in most circumstances that they can pass tax-free to their direct descendants, which could be their children or grandchildren or others? That's made up of £500,000 per person, up to £500,000 per person. We'll come back to that in a little bit. If you have total wealth when you pass away exceeding £500,000 per person, taxable wealth, the rate of tax on the excess is 40%, 40. So it's a hefty tax. Not always the most popular of taxes, but a hefty tax raises £3 billion plus per annum for the Treasury. That's inheritance tax. We'll come back to that in a moment. The second threat I want to spend a little bit of time talking to you about this evening is something that has gained quite a lot of press coverage in recent weeks, recent months, and that's care fees. So care fees become an issue when the NHS has stabilised a patient, but that patient can't return home, and that patient requires residential care. When that situation occurs, there's a question about who pays for that care. There's some important thresholds to remember here. I'm going to try not to throw too many figures at you, but here's some important thresholds. If an individual goes into care, they are means tested. Their ability to pay for that care is assessed. And if they have wealth, means testable wealth, exceeding £23,250, they will be required to pay for that care in full. There are some times when assets are disregarded. So a family home can be disregarded from that assessment if it's occupied by a spouse, a relative over 60, a dependent. But when that property becomes vacant because that person residing in it passes away or moves out, that property would be subject to that means test and would be included. And if the total value of the estate, including that property, exceeds £23,250, the resident in care would be expected to fund those fees. Okay, but you're left with as little as 14,250, because between the 14,250 and the 23,250, you would make a contribution. When your wealth gets down to £14,250, you will no longer have to pay towards your care costs out of your capital. So if inheritance tax leaves a minimum of £500,000 untouched, and care fees leaves a minimum of £14,250 untouched, there is a third threat which can leave your beneficiaries with nothing. We call that sideways disinheritance, which sounds really complicated. We also call it, a little bit tongue-in-cheek sometimes, toy boys, gold diggers. What we're talking about is remarriage. So when a couple have wills that leave everything to each other, and one of them passes away, the survivor is left owning everything. If that survivor meets somebody else and remarries, and then passes away, everything could pass to that new husband or wife. That new husband or wife may not remember the children of the first to die under the terms of their will. So if you picture husband and wife, one passes away, passes to the survivor, meets somebody else, passes away, passes sideways, that is a real life way that children and other beneficiaries are disinherited, often completely inadvertently, because not everybody is aware that when you get married, a will which you've written previously, not in contemplation of that marriage, is revoked, cancelled. When that will is revoked, any new will, or some rules called the rules of necessity, would decide who gets what. And it's through those rules, and then through the will of the second marriage, the second husband, the second wife, that beneficiaries can be completely disinherited. So there's three threats there. All can have a significant impact depending on personal circumstances and depending on events that follow after somebody's passed away. So let's look at those in a little bit more detail, and then we'll talk about some possible solutions to those issues. So I mentioned a threshold for inheritance tax, an allowance of £500,000. That's made up of two elements. Everybody has £325,000 allowance. That's the amount they can give away tax-free. Everybody has that. The second allowance that everybody can gain if they pass their family home to direct descendants. Direct descendants are children, grandchildren, etc. That's worth up to £175,000. And that's how we get to the 500, 325 plus the 175. That allowance can be transferred between married couples and civil partners. And as such, a married couple or civil partners have £1 million tax-free. There are people and institutions you can leave your money to and not pay any tax. So you can leave as much as you wish to your spouse, and that will always be tax-free. Never any tax to pay when you pass your money to your husband, wife, or civil partner. You can also leave as much as you wish tax-free to registered charities. So any gifts you leave to registered charities are free of inheritance tax. And there's a third group which you can leave your money to tax-free. And this one isn't so widely known. It's political parties. So if you are so inclined, you can leave as much as you wish tax-free to a political party. There are rules around. Okay, I'll carry on. So you can leave as much as you wish to political parties tax-free, and that can have the effect of reducing your taxable estate. The most important thing I can say about inheritance tax is that you can plan not to pay it. With advanced planning, arranging your legal affairs, you can plan to reduce, or in most cases actually avoid paying inheritance tax through effective planning. It's a lack of planning that usually costs people significantly when it comes to inheritance tax. So let's look a little bit deeper at care fees. So you may or may not be aware that 1 in 6 men and 1 in 3 women over the age of 80 will require residential care. Not great odds. Up to 150 homes are sold each day to fund care. That's a circumstance I mentioned before. Somebody goes into care, they own a property, they're required to pay their care because their assets exceed the £23,250. And the only way to fund that bill is to release the value locked in the home. And that is how homes are sold, up to 150 a day. How much does care cost locally to you? It varies around the country. We tend to take a figure of around £1,000 all in per week. The average stay in a care home is around 4 years. So you can do the maths. You can assess the impact on your own circumstances, your own estate. There has been talk very recently, renewed talk, of a care fee cap, capping the amount anybody will have to pay towards their care fees. There's a lot of detail yet to come out in the legislation and the discussions on that subject. But it would be inappropriate for me to pass personal comment, I think, but there's various commentators in the press who've been quite clear that it's unlikely the cavalry is coming over the horizon on this one, and the need to plan ahead, the need to protect still exists. So the situation occurs where a survivor has the whole property at risk, often because of something called joint ownership of property. There's different ways you can own your house. When you own it with another person, you can own it jointly with them. That means you both own, for succession purposes, you both own 100% of the property. You might think you own it 50-50, but if you own it jointly, you actually own it, for the rules of succession, 100% each. What that means is that if one of you passes away, the survivor, by operation of law, will own the whole property. Doesn't matter what your will says. That's the problem for most people. Most people don't necessarily realise that there's different ways you can own your property, and the vast majority of people own it jointly. It's nice and straightforward. It means it passes to your husband or wife. That might be fine in some circumstances. But if your husband or wife then requires residential care, they're left owning the whole property. That's a problem. The second way you can own property with another person is what we call tenants in common. Nothing to do with renting. It's just the technical name for the way you own your property, tenants in common. That means you own a share of a property with another. Usually the share is 50%. So if we have a typical scenario of a couple that own a house together, tenants in common, they will usually own it 50-50. What tenants in common allows is for you to decide where your 50% goes. Through your will, usually, you would stipulate where your 50% goes. So the problem here is usually caused by that joint ownership of property. Okay, I'm going to talk about a little bit about some of the solutions now. There's a very relatively simple solution for most people, which we call a trust will. A trust will is a method of protecting, ring fencing property. It's like a protective wrapper you can place around savings investments that protects it for the people you choose. Tina, would you display on screen for us the Trustwill infographic, please? Thank you. I'm going to use this to talk through to try and support my explanation of how a trust will works. So in this scenario here, we have Chris and Sam, who have 2 children, and they jointly own a house worth £200,000. Sadly, Chris passes away. Now, on the left hand of the two columns, the red column, we have how would happen with a standard will or with no will. So if Chris has a will leaving everything to Sam, or we don't have any will and everything passes to Sam because they own that house jointly, this is what would happen. Sam would then own 100% of the house. Okay, so Sam now owns a whole house. That's fine at this stage. However, there's various future life events that can occur which can have a dramatic impact on the inheritance that they plan to leave. If Sam decides to remarry, 100% of the house could pass to a new spouse when Sam dies, or through a later divorce. That means Chris and Sam's children might not inherit anything. That's the sideways inheritance I was talking about. Rolling on a few years, if Sam requires residential care, Sam has to use 100% of the house to self-fund residential care costs until only 23,250 is left. Then she starts funding a proportion of it. When Sam dies, the children might inherit only £23,250. So with a standard will, Chris and Sam's children may inherit nothing or up to 23,250 in the residential care scenario. On the right-hand side, we can walk through what would happen with a trust will. So with a trust will in place, they've changed the way they own a property to tenants in common. They now own 50% each. And when Chris passes away, Sam owns their 50% of the house, and Chris's 50% is protected by a trust. Now, trust can sometimes sound scary, but in this scenario, it's a relatively simple trust that says Sam can continue to live in the house for the rest of their life. If they need to move, they can sell the house and they can downsize. They can put the proceeds of a sale towards a new property. It's theirs for their lifetime, but it's not theirs to spend. Okay, so in this scenario here, we now have half the property owned by the trust and half the property owned by the survivor, who is Sam. So if Sam now decides to remarry, the 50% of the house owned by Chris is protected by the trust. And it can't pass to the new spouse when Sam passes away or if they divorce. So the children will inherit at least £100,000. So if you remember the box to the left, the children might not inherit anything. The children will, in this scenario, now inherit at least £100,000. Fast forward a few years and Sam requires residential care. If Sam uses 50% of the property to self-fund those residential care costs, only £23,250, until only £23,250 is left, but the other 50% is protected by the trust. Okay, it's not owned by Sam, it's owned by the trust. Because of that, the children will inherit, in that scenario, £123,250. Pretty big difference. So with a trust will, Chris and Sam's children will inherit a sizable sum, estimated between £100,000 and £123,250. That's how a trust will works. There's a variety of different trusts. It's crucial that you take advice from a professional who can talk you through the right trust for you and your circumstances. But they don't need to be scary. They can be quite simple and they can be highly effective at protecting what you've worked hard for. Now, you may have heard of something called a lifetime trust. So this here was a will trust we've just spoken about. You may have heard of something called a lifetime trust. Lifetime trusts require very careful consideration. They require a real understanding of someone's objectives, a thorough understanding of their circumstances, and really professional advice has to be sought before entering into a lifetime trust. I think it's fair to give them a health warning, a hugely effective estate planning tool in the right circumstances for the right person with the right objectives, but it's essential to take advice. Now, just a quick story on Trustwills I wanted to share with you. It's something that stayed with me. A colleague shared with me many years ago, and it really resonated with me, and I remember it to this day. And what he said to me was, if he was to pass away, he's married, if he was to pass away, he wishes his wife well. He wishes her absolute happiness. He hopes she meets somebody else and settles down and is completely happy. But he absolutely does not wish that new husband to have the benefit of his lifetime's hard work. That's where Trustwill comes in. Protect, provide for, make sure it passes where you want it to pass. Now, I saw a question pop up there about Trustwills for single people. There are numerous types of Trustwills. A number of them are suitable for single people. It depends on what you're trying to achieve. It depends on your circumstances. But absolutely, trusts are important and effective for single people as well as married couples. Thanks. Great question. Thank you for that. Okay, we're going to talk a little bit about something a little bit different now. Lasting power of attorney. Now, I'm sure most of you have heard of lasting power of attorney. It's a thing that people kind of think, oh, it's associated with old age. We'll do that later. We'll do that when we're feeling a bit iffy. A lasting power of attorney, I think, it's a little bit like an insurance policy. It's something you hope you'll never need to use. But if you do need to use it, you'll be very grateful that you planned ahead. If you think about, we all insure our houses, we all insure our cars. Our cars we have to insure, but our houses we all insure. And we hope never to claim on that house insurance. But one day, if you need to, you'll be grateful that you took the time to study the insurance, make the right choice, get the right policy, and be able to make that claim. So an LPA, lasting power of attorney, is a little bit similar to that in that you hope you never use it, but if you do need it, you'll be grateful you planned ahead, or your family will certainly be grateful you planned ahead. There's not always a warning of a loss of capacity. Okay, so lasting power of attorneys aren't only something you can put in place when you start feeling iffy. You don't always get advance notice of an illness. It can be quite sudden sometimes. You certainly don't get advance notice of an accident, a fall off a ladder, a bang on the head, a collision on the roads. And the effect of not planning can be significant. So a lasting power of attorney allows you to take control and appoint somebody you trust to manage your affairs if you're unable to do so. There's two types. A health and welfare power of attorney allows somebody to manage your health and welfare matters, so decisions about care, hospital treatment, where you live if you can't make that decision yourself, what you eat, how you dress, and really important things like life-sustaining treatment, whether it can or should be provided. And a financial lasting power of attorney, which allows you to appoint somebody to manage your finances. Could you just bring up the lasting power of attorney infographic for me, Tina? Thank you. So here a visual again for you, just to try to so we can walk through and explain the impact of not having a lasting power of attorney and the benefits of having one. So in this scenario, we've used me. So Alex suffers an unexpected illness or accident resulting in a loss of mental capacity. So what would happen if that happened to me and I didn't have a lasting power of attorney in place? My next of kin, in my case, my wife, it could be another family member, husband, wife, some partner, whatever it is, they don't have the legal right to make decisions for me. My wife does not have a legal right to make decisions for me. This is a very misunderstood concept. Many people assume that a husband or wife has the authority automatically to make decisions for their spouse if something happens to them. They don't. Sole bank accounts are frozen. Joint bank accounts are frozen in some circumstances. The bank has an obligation to protect the interests of their customer. And they will freeze sole accounts. And in some circumstances, they'll also freeze joint accounts. Bills can't be paid from my money. So bills that I usually cover the cost of cannot be paid from my money. Investment decisions can't be made. So any authority I've given to any financial advisor or institution to manage investments on my behalf, that becomes null and void at the point where I lose capacity. So investment decisions can't be made on my behalf. Property can't be sold. Also impacts things like mortgages when we talk about property. But property can't be sold, meaning a cohabiting partner can't move house if they wanted to. They're tied to the property which we own together. My next of kin don't have the legal right to make decisions about medical treatment. They might be consulted by the doctor, but they don't have the right to make decisions. That's an important distinction. And my next of kin don't have the legal right to make personal choices, for example, where I should live. Now, where I should live, what I should eat, how I should dress, they can be incredibly emotive choices, incredibly emotive issues for a family at a time when a loved one has lost capacity. And only through planning ahead can you give them, can you make the choice about who has that power to make those decisions for you. So if you don't plan ahead and you suffer an accident or illness which causes you to lose mental capacity, your next of kin can only get the legal authority to act on your behalf through a court order. Okay, so there is a path. If you don't plan ahead of an LPA, there is a path for your next of kin to gain that legal authority, but it's via a court order. They have to go through the court of protection. Like any court process, that is not quick. It's a long process. It's a costly process, considerably more costly than anything associated with a lasting power of attorney. It's also very intrusive. There's various details have to be disclosed to the court as part of that process, and there's various decisions which they will need to be involved in and their authority sought on an ongoing basis. Okay, so it's a long, costly, and intrusive process. Now, if we look at when I plan ahead and I put lasting power of attorney in place, so I put in place lasting power of attorney for both financial and health and care decisions, and I appoint a representative. I'll probably choose my wife. She'd probably be upset if I didn't. So I've appointed that legal representative to make decisions about my finances. That means the bank recognises my chosen person and recognises their legal authority to act on my behalf, to step into my shoes, and none of my accounts are frozen. Investment decisions can be made by my representatives. Bills can be paid as normal. And if needed, my property could be sold and a further one purchased. The representative has the legal right to make decisions about Alex's medical treatment. So not just are they going to be consulted, they have the legal right. And the representative can make personal choices for me, such as where I should live. So by planning ahead, you choose who should have legal authority to make decisions on your behalf if you're unable to make decisions for yourself. A lasting power of attorney costs far less than a court order, and the people you choose can step in as soon as they're needed. I wanted to share with you an extract from an article I read recently. A very famous situation of a famous person that suffered a situation recently where a lasting power of attorney would have made a very big difference. You probably read about it in the press. Kate Garraway. So Kate Garraway's husband, unfortunately, suffered significantly from coronavirus and spent a very long time in hospital, unable to speak or make any kind of decisions. Here's an extract from a journalist who interviewed Kate Garraway. The journalist was called Katie Binns. So Kate couldn't access the bank account or credit card accounts of her husband, couldn't access their joint savings, nor refinance the mortgage. When the family's mobiles broke, she was charged almost £900 for replacement handsets that would have been free had her husband, the account holder, been able to sign the paperwork. The knock-on effect was serious. She had to rely on friends for financial support. Kate Garraway is now a supporter, huge supporter, proactively talking about the importance of lasting power of attorney, because if her husband and her had put those powers of attorney in place ahead of his illness, of which he got no advance notice, she would have been in a position where she would have had access to his accounts. She would have had access to his bank, his credit cards, savings. She would have been able to continue with refinancing the mortgage, and she wouldn't have had to shell out £900 almost for 2 new mobile phones. So that's a real life example. You may have read about it. You can certainly go away and read about it if you have a Google. Quite an interesting story that really, I think, really brings home the point about why it's so important to plan ahead. Okay, just a quick health checkup before we move on from powers of attorney. There is a legal document that predates lasting power of attorney called an enduring power of attorney. You may have heard of it. An enduring power of attorney was a legal document that if you put a power of attorney in place prior to October 2007, that document would have been an enduring power of attorney. You can no longer make one. You couldn't make one after the 1st of October 2007. The reason I mention this as a health warning is because there was a lot of people that did put it in place in the final days of enduring power of attorney, with the belief that it was a simpler process, but it does bring some challenges. So an enduring power of attorney has to have been completely signed by all parties and witnessed before the 1st of October 2007. So if you have one, dig it out, make sure it's completely signed by you, by your attorneys and their witnesses. Otherwise, it can no longer be signed. It will no longer be valid. That's point number one. Point number two on enduring power of attorney is that it can only ever give somebody the authority to act in relation to your finances. It does not give anybody the authority to make health and care decisions for you. The third point on enduring power of attorney is that it can only be used once it's registered, and it can only be registered with a body called the Office of the Public Guardian. It can only be registered when the donor, that's the person that made the document, the person giving the power, when they have lost or are losing mental capacity. Registration takes several weeks, a few months, 12 weeks often, perhaps as an average. In that intervening period, nobody can make decisions for that person that has lost capacity. It's a really important distinction between enduring power of attorney and lasting power of attorney, because lasting power of attorney you can create today, get registered, and know that it's there to be used when your family need it. It's a real plan ahead tool. Okay, so quick health check there. If you have heard of it, if you have got one, have a quick check. Consider perhaps the benefits of reviewing that legal document. Okay, back to wills. So I started off saying there's no point making a will. It was a little bit tongue-in-cheek. A will is probably one of the most important legal documents any of us will ever sign. It will certainly only ever be used when we pass away. And at that point, it's too late to do something about it if it's wrong. So it's an important legal document. It's got to be got right, got to be signed right, stored safely. But I hope you take the point that just having a will might not be enough. If there's not much left to leave, what purpose does a will serve? Including trust within your will could be incredibly powerful. Putting in place lasting power of attorney could be incredibly important for your loved ones. Now, I'm going to move on to Q&A shortly and give that. I can see some questions popping up. It's difficult to follow them all when I'm speaking, so we'll move on to that in a moment. But before I do that, let's have a quick recap. So we've talked about three main threats. There are others, but I've talked about three main threats. Inheritance tax, a £500,000 allowance from most people, 40% inheritance tax charge on the amount over your allowance. You can give gifts to charity tax-free. You can give gifts to political parties tax-free. Gifts to your husband or wife, your spouse, your registered civil partner are always tax-free or free of inheritance tax. I've spoken about care fees. And if you have means testable assets over £23,250, you will be required to pay your care out of your capital. And I've spoken about size of disinheritance in the scenario where somebody meets somebody, one of a couple passes away, survivor meets somebody else, and the effect that could potentially have on the planned inheritance for the children. We've spoken about some possible solutions. I hope the infographics were useful to explain at a high level. It is really important that you take advice. Really important you take advice. These things, when I've seen problems occur over the years, those problems are usually only identified when it's too late to do something about it. If there's a problem with the will, if there's a problem with the trust, if there's a problem with the lasting power of attorney, those problems are usually recognised when it's too late to do something about it. Somebody's passed away, someone's lost capacity. So if there's one thing to do right, it's this. My top tips for you when you are choosing somebody to support you through this process, if you choose to do so, make sure the firm you choose is regulated by the Solicitors Regulation Authority. Not all firms are, not all will writers are regulated by the Solicitors Regulation Authority. I'm not saying they don't do a good job, but regulation gives you, as a consumer, protection. It ensures they work to certain standards, and it ensures they have insurance in place to protect you if anything were to go wrong. A crucial point, make sure they're regulated by the Solicitors Regulation Authority. And an obvious one, but check them out on Google first. Look at customer reviews, see what people have got to say about them. If you can't find anything, ask yourself why. Personally, I'd want to see excellent scores there. If I'm just going to trust this company with everything I've ever worked for, I want to see excellent scores on those reviews. Obviously, I work for the co-op, and I wouldn't work for them if those scores weren't excellent. It's important to note that there are certain legal things you can do yourself. So you can go online and do your own lasting power of attorney. You can go and buy a will writing kit from WH Smith. You can do things yourself. You can also represent yourself in court, manage your own divorce, do your own conveyance when you purchase a house. You can do many legal things yourself. But when things go wrong, that's when you would have valued the support of that legal professional. Okay, and as I mentioned, when things go wrong with wills and lasting power of attorney, it's usually discovered when it's too late. So I want to let you know, before we move on to the Q&A, that the co-op are able to provide telephone, video, and face-to-face legal services. Okay, so it's important to note that, I think not everybody does. Across England and Wales, you can arrange a home visit appointment, a video appointment, or a telephone appointment. So whether it's with the co-op or with anybody else you choose, please set the wheels in motion, take the next step. Procrastination is the enemy here. The estate planning sits on many people's to-do list, and unfortunately sometimes it sits there too long. So please take the next step, set those wheels in motion. You don't always get advance notice and the ability to plan ahead of an eventuality. Sometimes things happen very quickly. An estate planning review with the co-op costs nothing. You can arrange a meeting by telephone, video, or a home visit with an estate planner who can review your circumstances and can make recommendations about your planning, and that review will cost you nothing. If they make recommendations, they'll tell you exactly what those recommendations would cost for the co-op to support you with it and allow you to make an informed choice. And as a restless member, you are able to benefit from £50 off any of those services for a limited period of time. Thank you, Tina. Okay, so £50 off advised estate planning services. We also have a digital LPA platform on our website. We're going to post a link in the chat in a moment. To set those wheels in motion, to benefit from that review of your estate planning at no cost to you, so you generally have nothing to lose, and to register to receive your £50 off voucher, click the link in the chat, enter your name, enter your phone number. We'll give you a call tomorrow. We can answer any questions you've got, and we can set those wheels in motion for you. Okay, that offer of £50 off does expire on the 2nd of December. Our diaries are busy. I really advocate taking action promptly if you intend to do so. Okay, now I've spoken a lot. It's gone pretty quickly for me. I hope it's gone as quickly for you. I'm going to pause now and ask Nicole to step in and support us with a Q&A. We don't have long left. I should say, please don't ask me, don't divulge personal information in this environment. It is recorded. If you have a question which requires you to divulge personal information, which many do, please just click the link, enter your phone number and your name. We'll give you a call. We're delighted to answer your question. Okay, so for this scenario here, let's just keep those without personal details, please. Nicole, over to you.
Okay, thanks, Alex. Very informative. A few comments coming through to say thank you. That was really informative, very clearly put forward. So I appreciate you putting that forward. The first question from Julia is about trusts. What happens if a trust if in a trust will, the surviving partner wants to sell a house and buy another one using the funds from the deceased person, which is held in trust? Would that money be separated back to the trust?
So it's a great question. It depends on the terms of the trust. So we would always talk about what someone's looking to achieve, or what flexibility they like to build into that trust when we're helping build that for them. But in the kind of scenario I described there, then a life interest trust, which is what I was describing on screen, generally has the powers for the house property to be sold and the proceeds owned by the trust to be used to buy another property. So there's a high degree of flexibility there.
Okay, that's interesting. So question from Susan. I'm a widow and own my house. Will a trust will ensure my house is passed to my children and not used for the care fees if needed?
Okay, so that's I think the vehicle there would be potentially lifetime trust versus trust will. I think the objectives need to be very carefully considered. There's rules around actions you take which can move assets beyond the reach of care fees. It has to be very carefully considered. The objectives have to be clear, and take advice would be my recommendation.
Okay, this one comes from Dwinda. If a spouse is in hospital, the doctor asks for the next of kin without asking to see if they have an LPA. Why is that different than a legal, I suppose, than going to the bank or going to the mobile phone?
So it's a difference, but asking next of kin for their views or perspective is different to giving someone a legal authority to act as if they were you. So there is a difference there. When you grant somebody the power and the power of attorney, they are making decisions as if it was you. So when you decide whether you do or don't have an operation, you will decide whether you do or don't, whatever it is, they're acting as you. In the scenario which was described then, without the power of attorney, the doctor's asking for someone's view, opinion, and doesn't have to follow it.
Okay. This is an interesting question. It's come from a couple of people. It says, can more than one person have power of attorney over a single person? So can you give power of attorney to 2 or more people for, so if you had 3 children, would you give them all power of attorney?
Great question. So there's different ways you can appoint attorneys, and you absolutely can have more than one. You can also have reserves. How you appoint them, how you allow them to act, the powers that you give them need to be carefully considered. And again, it's the kind of thing we talk through with somebody at a review and understand really about those circumstances, understand what we're looking to achieve, what kind of powers they want to grant, and who they want to grant them to, and kind of in what order, if there is an order. There's different ways to achieve that, but absolutely it can be achieved. Okay.
I thought this one on wills was a good question. Can I add to my will without doing a new will?
A great question. Simple answer, no. Technically, yes, you can do something called, without complicating it, you can do something called a codicil, which is a kind of an amendment to your will, separate legal documents. It's alongside your will. Honestly, it gets a bit messy often with codicils. You've got 2 separate legal documents, one gets lost, it causes great problems. So we would usually advocate, if you want to make changes, put a new will in place.
Okay, and I thought this was a really good question as well. Can spouses have mutual LPOA and adult children have LPOAs too, in case something happens to both parents at the same time?
Yeah, fantastic question. That might be the perfect order of events that you might appoint your husband or wife as your attorney in the first instance, and you might appoint your children's attorneys in a secondary capacity. So if your husband or wife can't act, that would be one of the scenarios we'd talk through. Absolutely.
Okay, so it's always good to have a backup.
Absolutely, yeah.
Okay, I think those were kind of the main sort of themes that came out from the members who joined today. So yeah, I'm just having a quick look through. Oh, one point. Does this information relate to Northern Ireland? I think we sent on the email that we put out that it was England and Wales.
So what I've spoken around today is predominantly England and Wales. There are some of I've used actually the thresholds in England when we've spoken today for ground care fees. There are some differences for Wales. In Northern Ireland and in Scotland, the laws are hugely similar, but there are important differences. So we don't operate in those legal jurisdictions because of those important differences. But we do have regulated partners in both those jurisdictions that we can pass people on to if they wish.
Okay. Last question, because I kind of know we're getting to time. When one partner dies and the unused inheritance tax allowance goes to the surviving spouse, does that include the 175k as well as the 325k?
Yes, it can.
Yep. Okay.
It can.
Great stuff.
We've overrun a little bit. Thank you so much for listening to me for 50 odd minutes. It's been a pleasure speaking to you all, and yeah, please do pop any feedback in the chat, provide it to Nicole. And as I said, procrastination is the enemy here. So please, whatever you do, whether it's with the co-op or anywhere else, just go and do something. Don't be one of the people that regrets not doing so.